that as it may, allow me also, colleagues, to give you a brief read of the bios of our speakers for the talk today. Our first speaker will be Prof. Dube, and Prof. Dube is a full professor of the international law at the University of South Africa, where he serves as the acting director of the School of Law at the College of Law. He holds, amongst others, a Doctor of Laws degree from the University of Western Cape, a Master's of Business Leadership qualification from Unisa, and is a qualified pilot fixed wing. He also serves on the board of the African Peer Group Network. Prof. Dube is also the editor-in-chief of South African Yearbook of International Law, a DHET accredited journal, and heads of the research division at Black Forum South Africa, where he is instrumental in establishing a new journal, the African Fikira Multidisciplinary Journal. His research interests include leadership, international criminal law, comparative constitutionalism, the African Criminal Court, the law of war, aviation law, universal jurisdiction, and business law. Prof. Dube has previously served as a law researcher to Justice T.H. Madala at the Constitutional Court of South Africa, Johannesburg. He runs a research-focused YouTube channel, aptly named The Research Platform, which imparts knowledge on research and writing within the academic space. He also runs a second channel styled Angelo Dube, The Flying Jurist, and a podcast of the same name on Spotify, both of which focus on empowering emerging aviators and other young scholars. Our second speaker for the talk today will be retired Lieutenant General Derek Mbuyiselo Mgwebi. Lieutenant General Derek Mbuyiselo Mgwebi was born on the 28th of December 1956. He has more than 35 years of national and international military experience. He holds a degree in business administration as well as a diploma in defense management. He held several positions in the South African National Defense Force, and he also served in the African Union and the United Nations missions within the African continent. Amongst others, he served as the general officer, commanding Joint Operational Headquarters from 2003 to 2004. He was then appointed the force commander of the African Union mission in Burundi, after which he became the UN Operation in Burundi force commander from 2004 to 2006. On completion of his assignment in Burundi, he served as a Chief of Human Resources of the South African National Defense Force from 2007 to 2011. From 2011 to 2015, he was appointed Chief of Joint Operations of the South African National Defense Force. Subsequently, in 2015, he was designated as the UN Organization Stabilization Mission in the Democratic Republic of Congo Force Commander, but only started serving from 2016 up until 2018. Following his appointment in the DRC in 2018, General Mgwebi retired from official military duties. He was then appointed as the Acting General Military Veterans Affairs in the Republic of South Africa from 2018 to 2020. He is happily married to Busisiwe Mgwebi and are blessed with 4 children, 2 sons, Mpho, Fezile, and 2 daughters, Tabisa and Tabile. Our third speaker will be Prof. Martha Bradley. Martha Bradley is an associate professor in the Department of Public Law at the University of Johannesburg, South Africa. Her publishing record includes publication in the International Review of the Red Cross, the Journal of International Humanitarian Legal Studies, and upcoming a monograph titled Non-International Armed Conflict, Classification and Controversies, with Hart publishing. She teaches at the International Institute for Humanitarian Law in San Remo on a regular basis and sits on the editorial advisory board of the Max Planck Yearbook of United Nations Law. Prof. Martha is the 2023 Land Steinmark Fellow at the Institute of International Law and International Relations at the University of Graz in Austria. Our fourth speaker is a student of our own, Miss Michelle Panashe Zororo. She has a passion for law and a commitment to excellence. Michelle has garnered a diverse range of experiences in academic journey. She is currently serving as a legal intern at Kian Armstrong and Associates, and Michelle has demonstrated her dedication and skills in the legal field in this way. Michelle's achievements are noteworthy having clinched victory in the Unisa moot court competition in 2022 rather. She has also presented Unisa at the Christoph Haynes African Court on Human and People's Rights moot court competition in Ghana in 2023. Further, she has done vacation work with Schlinder's attorneys, showcasing and advancing her prowess in legal advocacy. Michelle's involvement extends to leadership roles, including her position as the Executive Secretary of Health at the Federation of African Law Students. She is also the Secretary of the Unisa Law Students Association in Tshwane and is a founding member and Chief Legal Administrator of the Unisa Law Students Association Student Disciplinary Representative Committee, showcasing her commitment to maintaining a fair and just academic environment. Outside law, Michelle serves as a secretary and an ambassador of change at Think Big 39, which is a non-profit organization, and as a researcher at Unveiling Africa, which displays her commitment to social impact and research. Colleagues, allow me at this juncture to call upon, on behalf of Prof. Kole, Professor Dube, who's going to give us a welcome address. Thank you.
Ladies and gentlemen, standing on the protocol already established by Dr. Ngube, I would like to greet you and say good morning. Sanbonani, Afsheni, Dumelang, Minjani, Huyamore. My task is easy. I am representing the Dinari in absentia, Professor John Olautekole, and his acting Deputy Executive Dean, Professor Budeli Namakonde. Mine is to simply welcome you to this gathering and to thank you for pulling through to this seminar where we look at the conflict in Gaza, where we look specifically at the interaction between international law and various aspects of what is going on in Gaza, particularly from the angle of military law. My colleagues would stretch it and look towards spaces such as urban conflict within the ambit of international humanitarian law, which was previously known as the law of war. I must confess my affinity for the term the law of war. It had that ring to it that made you stand up and want to listen to what we're talking about. But when we changed it to IHL, International Humanitarian Law, we sort of put a teddy bear feeling to it. And yet we're not dealing with teddy bears here. We're dealing with the issues in Gaza, which is the theater of war. We're basically looking at how do we then lessen human suffering in the context of the theater of war? How do we limit the means and methods of warfare? Everything that we're trying to unpack and analyze in this seminar is geared towards the use of the term conflict and war. But for some reason, we've pushed it towards the teddy bear side. It's a bit fluffy. It's IHL. It's international humanitarian law. To the person on the street who doesn't even know what you're talking about, like, I'd rather do insurance law. I don't know what humanitarian law is. Is it the law of humans? They would ask. But if we go back to the basics and refer to this as the law of war, everyone has been in a war, whether you're fighting that bully who was taking your lunch money in grade 1, or you're fighting a taxi driver who has just gone through a red robot. It is a conflict of some sort. I hope Professor Bradley will perhaps illuminate us when she goes into the area of urban warfare, or war in the context of the urban jungle, because the fact that war no longer takes place in the open spaces that it used to in the past. We now meet, from tall building to tall building, and we fight. Ladies and gentlemen, I hope we'll also benefit from the presentation by General Mgwebi. It is always nice to have practitioners with us, so that when we give, the theoretical aspects of the law of war, they come in with the lived experiences. They give nuances that might not easily jump out at the textbook lawyer So that now gives us a rich tapestry, with which we now weave this rug of, dealing with military law and mainstreaming it in the context of higher education, as we seek to do with these gatherings. Ladies and gentlemen, my colleague, Dr. Mhlongo, will at some point speak at length about where we've come from with this seminar. It is not for me to go into the history of this seminar, but it's only just to mention what today is about and how important it is in the context of a world that is grappling with conflict on a daily basis. Unfortunately, we need to remind ourselves continuously with gatherings such as this. If I told you about Mozambique today, you would be, what's happening in Mozambique? There's a beach there. I can fly to Maputo. I can sit and sip some cocktails and put that on Instagram and Twitter and get some likes. That's what would be in your minds. But not so long ago, we're dealing with the issue in Mozambique. Where is it today? None of us know. If I put up 10 million and said, in this house, tell me what's the situation in Mozambique now, I would go home with my 10 million safe, because nobody knows. Because mainstream media has moved on. Social media has moved on. Our shock at what is happening in these spaces is transient. It happens tonight. Tomorrow we're waking up with a scandal of a politician. We're running with that. We've forgotten that there are people suffering in DR Congo, that there are people suffering in the Sahel, that there were abducted girls by Boko Haram in Nigeria, that the Horn of Africa is not stable. We forget these things because we've allowed ourselves over time to have the pace of how we interact with social things. We've allowed ourselves to have the media dictate to us, mainstream media. If it's not on CNN, if it's not on Newsroom Africa, then I don't know about it. Or if it's not there, it doesn't exist. And yet we live in a continent that is rife with conflicts of this nature. Coups d'etat everywhere. And if we don't take spaces like this to remind ourselves that this is the scourge of our times, we will not be able to move forward as a society. With those few words, I would like to welcome those of us in the house and those of us training online, and I wish you fruitful deliberations as we go forward today. Thank you.
Thank you, Prof. Dube, for the warm words of welcome. Without further ado, colleagues, allow me to introduce Dr. Linda Mhlongo, who is the acting manager of strategic projects in the College of Law, Unisa, who's going to lay out the background of mainstreaming military law, the military law project at the University of South Africa. Dr. Mhlongo, you may come through. Thank you.
Good morning, colleagues. Good morning, colleagues. That's much better. I would like to once again welcome you all to this seminar that is titled The Justice in Focus, Unpacking the International Court of Justice's landmark ruling on the case brought by South Africa against Israel concerning the ongoing Gaza conflict. So this, we were lucky actually. In fact, I think ever since we started the project, we were very lucky that around this time, there's something to talk about at the beginning of the year. So the project started in 2022, and we had our very first seminar, and there we looked at child gangsterism and urban conflict. It was a success, and we're just trying, out the project. We were not sure if it was going to be success. It was, and then we decided to look at a broader picture at Unisa from the College of Law, and then what we then did was to embark on a journey to bring in military law. And that is because right now at Unisa, we don't have military law as a module for our LLB curriculum. We also don't have a short learning program. We also don't have a master's. And we thought maybe let's just start out. It's just that, like I said, we're like with the unfortunate events that were happening. And then we created this as a project within the Unisa College of Law. And at first we thought that we'd just focus on military law practitioners, but the idea became bigger, and it's now a flagship within the Unisa College of Law. And we're not just looking at mainstreaming military law practitioners, because at first that was the idea, and we're going to look at the fact that even though military law practitioners, they undergo the same LLB, they don't have access, or they don't practice in our courts, they practice in military law courts. So we then changed, although that is still part of the project, but then we broadened the scope in terms of now bringing into the curriculum, and we are also going to look at a matter of engaged scholarship. And then last year around this time, well, in March, we had a second seminar. In there, we looked at China's military drills in Taiwan. I'm sure some of you remember that one. But like Prof said, sometimes we move too quickly with these things. It just becomes something that's happening in social media. We deliberate and we move on. But last year, that's what we looked at. But something interesting happened. Towards the end of the year, we had a conference, an annual conference. Unisa partnered with the African Peer Growth Network, and within that conference, we created a parallel high-level session where we invited different scholars from different backgrounds, and they came and talked about the law of armed conflict, and we titled that particular theme Centering International Humanitarian Law in the Main Discourse in Geopolitics Today. Once again, that one was a success, and we have actually requested the speakers from that high-level panel to actually publish their presentations. They have agreed, they are working on those, and we are looking forward to actually publish those talks, because it literally went on until around 2. We started in the morning. When the Q&A came, it was so robust that people didn't even want to have lunch. So with that, we then took advantage of the ICJ's decision and made it a theme for this particular seminar. And that's where we are. And one might wonder why military law. At the end of the day, we can't ignore what's happening around us. And I think for the past 2 years, we have seen in social media and on news that the Western Cape province wants to actually be independent. And you might wonder, for me, if you would like to know my opinion, I don't think we can get that without a civil war in South Africa. And so you might think that these things are happening in other countries and you're not affected, but who knows, we might find ourselves in civil war. And right now, like I said, I'm not sure about other universities. Unisa is only now starting to bring in military law into the curriculum. And we are hoping that this will be a success, because at the end of the day, we also, the Russia, Ukraine conflict. It cost us a lot. And we found ourselves thinking, can we really ignore military law? And for me, the truth is we cannot, and it needs to form part of the curriculum, which is why we then decided that we are going to mainstream military law and make it a project at Unisa. And with this project, we are hoping that as a starter, we are going to have a short learning program in military law. We are in the process of engaging other stakeholders, including scholars, people in military, who are going to help us develop the short learning program. And also with this, we are looking at the M level. So we are maybe we're looking at 3 years from now, going to develop it into a master's course. And we are going to be reaching out to some of the experts in the field to assist us with that project as well. But in terms of the short learning program, we have already started the talks. We are well underway, and we are hoping that by next year, the short learning program will be rolling out at Unisa. And now, for the speakers, and this is a humble request. So we are still in the beginning of the project, and we would appreciate it if you could develop your presentations into papers, and those papers may be used as study materials for the students who are going to be registering for this short learning program. So we do really request that you look at publishing, and we are going to talk about some of the journals that we have within the college that you can target for your papers. And another thing, within this project, we have a book project that we are busy with, and that is motivated by the fact that we have looked at the scholarship that is out there regarding this particular topic, but we felt like it's not written from an African perspective. So we want to have a book that is going to be prescribed for the SLP, a book that is going to be prescribed for the masters, that is going to be written by Africans for Africans, because we do have certain factors that only apply to us, and we feel like we need to take those factors into consideration. So that's what the mainstreaming military law at Unisa project looks like currently, and we do really appreciate your presence online and the people that are here. You are making it a success. We are on year 3 now, and it's only a success simply because of your support. So we really, really appreciate your presence and your engagements. And I am looking forward to actually engaging with the speakers, and all the best to all of them. Thank you so much.
Thank you, Dr. Mhlongo, for laying a foundation and giving us insights on the military law project, which the College of Law in the University of South Africa is tabling. It seems like a very interesting project, and I hope it comes through as it tackles contemporary issues. We are gathered today, colleagues, because of issues which precipitated between the Israel and Palestine concerning genocide practices, and of course the case between South Africa and Israel in the International Court of Justice. The issue and the talk today, colleagues, invokes a lot of emotion, and it cuts across everyone in the legal fraternity. It invites even people from different departments, as most of us here are not necessarily international humanitarian lawyers, but are in the legal fraternity, and this issue cuts across us in one way or the other. So I think it is quite a topic really which deserves deliberations, and we thank, of course, the College of Law for organizing it. And without any further ado, colleagues, please allow me to introduce our first speaker, who will lay the foundation to today's talk. And please take note of your questions and comments and preserve them for a Q&A session which will follow after all the speakers have given their deliberations. Colleagues, one more thing. Please ensure that your mic is off, even if you're attending in person. Please make sure that although you might have logged in, your mic is always off so that there's no sound distortion. Colleagues, allow me to introduce once again Prof. Dube to lay today's talk. Thank you.
Bit of a challenge. Okay, I'll speak from my head. No, it's fine. I don't want to mess up the setup here. But let me convert this into a tablet and see if that would help. Okay, I'll have to speak from my head. My setup is compromising me. Ladies and gentlemen, my title, and I sent it to you, Doc, yesterday, but because it was in this computer now that I've just closed, and I can't use because of the setup here, it's escaping my mind. But at the gist of my talk today is the question, are we civilized yet? I know that my talk will take the discussion around the Gaza conflict away from the theater of war into the halls of the great Peace Palace in The Hague, in the Netherlands, which is the context of the question I am posing. It's a decolonial approach to a question of international law that flows from the South Africa versus Israel case. Program Director, if I can just get an indication of how much time I have so I can time myself and not go beyond what is allocated. Thank you. I will time myself now. My talk moves the focus from the theater of war. My general will handle the theater of war afterwards, and so will Professor Bradley. I am interested in the inner workings of the halls of the Peace Palace, which was introduced to a number of our population recently by the genocide allegations against Israel in the case for provisional measures that went on in January of 2024. We know that the location of the case that South Africa brought was squarely within the Genocide Convention. We know that they went back and forth about whether it ought to be there or not. We know that Israel wanted to move it from the center line of the Geneva Convention and place it elsewhere. Israel wanted to place it in the context of simple, ordinary day-to-day warfare. It wanted to place it in the context of urban warfare in order to avoid any obligations under the Genocide Convention. For the purposes of the provisional measures judgment, that was not successful. And we applaud that because if one looks at why the entire scheme of the ICJ was brought about, it was simply to deal with state-to-state disputes, but also having been shocked by the doings of Hitler in the genocide against the Jews. The community of states had come together and they had said, never again. We shall never see this happening. We shall never have a world where impunity can thrive. How then do we prevent impunity from thriving? Simple. They decided to create a convention that will regulate genocide. and say that every state has obligations under that particular convention. And the platform for holding those states accountable would then be the International Court of Justice, the ICJ. Preceded before it by the Permanent Court of International Justice in the 1920s, in the early 1900s. Under the League of Nations, the Permanent Court of International Justice was created. It then morphed into what we have today as the ICJ. In my talk, I will go back to the days of the ICJ in order to ground what I'm about to say. Ladies and gentlemen, if there are scholars of international law here, they will recall that for this court to deal with the dispute between South Africa and Israel, it had to ask itself, which law must we apply? In other words, what are the sources of international law that this court must concern itself with? Article 38(1) of the ICJ statute gives the court the parameters that govern the sources it can rely on. At the very top will be your conventions, your treaties, your agreements, such as the Geneva Convention. Also included there will be your customs. In other words, practices of states over time that they have come to embrace as binding upon themselves. That will help the court determine any dispute before it. The third one, which will be the center of my talk today, is what we call general principles of international law recognized by civilized nations. The last one would be what you call the writings of eminent jurists. The language is not the same as it appears in the statute, but that's the summary of the last source of international law, the writings of eminent jurists. When I become an eminent jurist someday, the path is long, I'm still working towards that. When I become an eminent jurist, I will be a secondary source of law for the ICJ. Well and good. Those are settled. We now come to the third source, which I said will ground the center of my talk today. The general principles of law recognized by civilized nations. What are these general principles and where do we find them? What do they look like? Unfortunately, unlike custom, the court has not been able to unpack how we determine general principles. For customary law, it's easy. We need opinio juris. In other words, do states in their minds believe that this is a norm and it binds us? We also need practice. Over time, you must see evidence of states practicing a particular thing because they believe that a particular rule in relation to that thing binds them. There is ample scholarship and jurisprudence on that. We don't have to talk about it. What we have to talk about is, what are these general principles? Are these principles that obtain in the South African legal framework? Are these principles that obtain at the international level? You will notice that the International Law Commission began around 2017, 2018 to work on these issues. The issue of general principles. Because since the very early 1940s, 1920s, scholars have been toying with this idea of general principles, and there's no agreement on it. My take is going to be very, very different because it comes from a global South perspective. It comes from a toil perspective. It comes from a decolonial perspective. And why is it coming from a decolonial perspective? Because we were schooled by our students around 2015, 2016, that we're feeding them Eurocentric knowledge, and we need to turn it around, turn the house upside down, and feed them things that come from Africa. That's what grounds my talk today. General principles of law are basically the principles that obtain within our legal framework as different jurisdictions, as South Africa, as Botswana, as Ghana, as Cote d'Ivoire, as Cape Verde, as any other state. But also they can operate at the international level. These could be principles that states themselves at the international level regard as principles that generally apply to them. They hardly feature in the court, mainly because when the court has to deal with a particular matter, it already has enough sources from custom, from treaty, that it hardly touches on general principles. But we've seen many spaces where the court had resort to general principles. And my take on this is that most, if not all, the principles that the court has drawn from are from the global north. They're Eurocentric. I make the example of what grounds our desire to punish perpetrators of genocide, perpetrators of crimes against humanity. We call them hostis humani generis. In other words, we call them enemies of humankind. That's a principle. But it's at the foundation of prosecuting those who commit war crimes. Why? Because it comes from Roman law. It's even written in Latin. What is Roman law? It's the law of the tribe called Romans. It's customary law of the Roman tribe. But we are eager and easy to embrace it as part of international law because it comes from the global north. I argue in my argument, in my presentation, that in this current case, SA versus Israel, we missed a chance to decolonize international law and perhaps to some extent decolonize the International Court of Justice as well. How? In South Africa, as a starting point, and then in Africa, as I extend, we have a very wonderful concept called Ubuntu. If you ask the uninitiated on the street, they would tell you it's a Zulu word that means I am because you are, therefore I am. You can put me in a footnote and quote me and say that I said, that is misleading. It is wrong. But that's the scholarship we've come to ingest and never ask questions. The word Ubuntu is common amongst 4 Nguni languages. It's not simply a Zulu word. It's common within the Xhosa language. It's common within isiZulu. It's common within isiNdebele. It's common within Siswati. The 4 Nguni languages equally own that particular term. Not only that, you move to any other people in Africa, you will find a similar manifestation of the same word. In Malawi, it might be called Motu with an H before the U. In Mozambique, it's something similar. If my computer had not done, I would be calling all these names to demonstrate what I'm talking about. All the way to Congo, Tanzania, you get manifestations of this particular term. It simply speaks to the humanity of every human being, the interconnectedness of each and every human being. It also speaks to the Godhead, the fact that Ndu was the origin of the Bantu, who then, from there, were able to extrapolate Ubuntu. From Ndu to Bantu to Ubuntu. There's a golden thread running through. It determines the interactions between each and every individual. It speaks about shared responsibilities and shared rights and responsibilities amongst a people or a group of people. How did you miss a chance to mainstream Ubuntu into the court's language? We could have argued as South Africa that not only are the actions of Israel inhumane, which is a Eurocentric term that we understand fully well because it is in English. No one will ask, what does human mean? What's the origin of humanness? Nobody will ask that. We'll just accept it. It is what it is. It's humane. They need to treat the others humanely. We will even go to Henry Dunant, to whom we accredit IHL today, and say he was walking through the Battle of Solferino. He saw suffering, and his heart was touched. He wasn't an African, but that was Ubuntu. If he had no Ubuntu, he would have walked past and said, hey, look at those dead bodies, and moved on with his life. But something triggered in him, and he started lobbying to say, how do we reduce suffering in war? How do we, cut out unnecessary suffering in war? Once you've neutralized your enemy, should you really continue? Because the enemy is neutralized. Let's come together and have rules around that. So we'll readily embrace it because the West has already long embraced it. But when it comes to Ubuntu, we will struggle to embrace it. We'll ask, what exactly is Ubuntu? Define it. Just as we once posed questions, you can't demand things that you can't define. Some people say it when students asked for decolonized education. Today, we are riding on that wave of decolonized education. So Ubuntu should have been argued as a norm, as a principle, as a general principle, that a civilized nation called South Africa and others on the continent regard as principles within their legal frameworks. We should have done that to test if the court itself is decolonized. We should have done that to test if the legal fraternity is ready to embrace a norm from Africa. When in the 1914s, when the Committee of Jurists met to decide on the statute of the PICJ, the Permanent International Court of Justice, and they had to tackle the question, what are these civilized nations? Because remember, we said it's a general principle of law, and it must be recognized, not just by anybody, but by what we call a civilized nation. In 1914, we were not regarded as a civilized nation. We were regarded as a barbarous nation. In fact, there were three levels. There was the inner core, which was civilized. Then there was, after the inner core, you moved towards the barbarous nation. You know, there was the second layer. It's almost civilized. If you push it a little bit better, it can get civilized. It's barbaric, but it's getting there. Then you had the outer core, which was utterly, unsavable. You couldn't save it. It was called savage. Those nations were not regarded as civilized, which is why all the norms that the ICJ has drawn from to develop international law and deal with disputes such as South Africa versus Israel have been Eurocentric in nature, because we were classified at that time as uncivilized. We continue to claim we're civilized, and that claim is shaky because those who generated these instruments and the scholarship behind it continue to regard the entire continent as uncivilized. We missed out on an opportunity there to actually test and push the boundaries and see. Here is a norm. It comes from a civilized group of nations, because it's not a South African term. It's common across Africa, And then we would have had the court respond to that. If we have the guts to stand up and say, Israel must stop doing this because it is inhumane. If we had the guts in the 1948 to say, whatever happened after Hitler shocked the conscience of humankind, and therefore we're going to draw from those norms to create law. Why can't we draw from African norms to create law that regulates the conduct of states? So, ladies and gentlemen, that is the long and short of my presentation. I posed the question, did we miss a chance to decolonize the ICJ? Did we miss a chance to decolonize international law by not advancing Ubuntu as we have done in our local context? We have done so in the interim constitution as a republic, where in the post-assembly of the constitution, we included Ubuntu as a value. But when we moved from the interim constitution to the final, not final, it's been amended 17 times, to the 1994 constitution, we dropped Ubuntu. It didn't feature anywhere. Fortunately, Justice Madala and Justice Yvonne Mohoro had already interrogated this issue and placed Ubuntu at the center of our constitutional jurisprudence in the S versus Makwanyane case. That it had now become precedent, it continued into the post-1994 constitution, even though it no longer appears as a constitutional value. But its place in our legal framework is firmly cemented. We could have exported this great, legal principle from the domestic to the international plane, and we missed out on that. We could also have argued that Ubuntu informs the legal architecture of the African Union, such as the African Charter on Human and People's Rights, which emphasizes on group rights, rights of the collective, which can be traced back to Ubuntu. We could have said, this norm is not just a domestic norm, it's also a norm at the international plane. It fits the requirements, or it fits the mold of what you find in Article 38, sub 1, sub C of the ICJ statute. This is a paper still under construction. Those are my thoughts to this level. I thank you, Program Director.
Thank you, Prof. Dube, for opening the talk today. I must say, the saying is still relevant to say it's always good to stand on the shoulder of the giants to see further. I know some of us may not have seen this perspective of the question that your talk posed. Did we really miss a chance to decolonize international law? I don't know, Prof, should that saying also be decolonized? Standing on the shoulder of the giant? Thank you. Colleagues, without wasting more time, please allow me to introduce our second speaker of the day, who's the retired Lieutenant General Derek Mbuyiselo Mgwebi. Ndate, the time is now. Thank you.
Thank you, Program Director, for giving me the floor. That's what the French would say. And also allow me to thank the College of Law for inviting me to share my views with regards to what's happening in Gaza. Professor Dube, I'll try and do justice with regards to confining myself more on the military aspects of what's taking place there. To those present here and our colleagues online, thank you for attending and being part of what's happening. The issue of Gaza should be understood in the context of the Palestine-Israel conflict, which has been going on for almost 75 years. And within that period, around about 15 wars have been fought, and a lot has happened. Now, lately, when we look at the incident of 7 October 2023, and this is what now we are looking at. And of course, we need to take into account what is happening all along. Well, the question which arises out of this is Israel as a state is a signatory to the convention which we're speaking to. Hamas is not. And trying to focus on the issue of the 7th October 2023, then we'll realize that Hamas deliberately planned and executed their operation. And I think they did a good job. But the question is, did they, in the execution of their operation, took into account children, women, and the old people in that context? Then the evidence at hand indicates that they have not done a good job in that regard. Well, some might argue that they are not the signatories to the Geneva Convention. But at the end of the day, if you go to the issue of conducting war, even before the convention, you would go to all the religious pieces of belief. You would then get to understand there are some guidelines of how we're supposed to deal with each other in the battlefield. And again, the issue of Ubuntu, as at least explained by Professor Dube, also applies. When one is no longer in a position to fight, what then? So these are the issues which are facing us when we look at that as far as Hamas is concerned. But Israel, as a state and a signatory, with a political leadership, in response to that incident of 7 October, with all our understanding, which speaks to the right to self-defense, they had to do something which they're entitled to, like all of us. But the question which arises out of that, to what extent do you use force in terms of protecting yourself? So the proportionality of that force becomes then an issue. And as a state, Israel has got a defense force and has got a policy which speaks to their defense force. And that defense force, with their generals and all the officers, they are expected to develop their own military strategies. And within that, they also expected to have doctrine which speaks to how to conduct war in any situation. That's what's expected of them. And of course, they train their soldiers accordingly at all levels. Now, I have looked then at the invitation by Dr. Mhlongo that I must come and speak on this issue. Then I've decided to look at the military rules of engagement in the Gaza conflict. Now, if you accept that Hamas did what they did, the question is for them to dig those tunnels and be able to execute that operation, where were the intelligence services of Israel, which we know to be among the best in the world? Not only that they were able to dig the tunnels and go through, but they were also able to inflict the kind of damage which they have, and also take away hostages with them, at the numbers which are being mentioned. And presently we are told there might be about 130 of those hostages still alive somewhere in the hands of Hamas. So the intelligence services of Israel, there's a question mark there. What happened? Is there an intelligence failure from their side? And of course, they would be very angry, and hence the response would be what now we are witnessing, because they need to prove to their masters that they are really professional in terms of what they do. Now, the response by the Israel Defense Force is informed by the political class. And of course, if you go to the decision of the ICJ with regards to what South Africa was asking for in terms of the provisional measures, then you realize out of about 7 of those, only 1 which was not acceded to, which is a cessation of hostilities. But if you look at the other 6, then it's implied that Israel cannot continue as they've been doing. But of course, we all know that they have not probably acceded to that. But we hope within that 30-day period, in that report, they'll be able at least to respond. Now, the military is expected to be subordinate to the political leadership of any country. Now, if you look at the statements made by the political leadership of Israel, when they refer to the Palestinians and Hamas as human animals, it will remind you of 1994 genocide in Rwanda, when the Tutsis were referred to as cockroaches. What do you do to a cockroach? Yeah. So exactly from a military perspective, looking at the military of, of Israel, you are dealing with the kids at a troop level who are almost 18 to 22 years old. And you are dealing with the people on the ground who might be 20 to 26 years old, who are lieutenants and captains. who are the ones right there in the forefront of this battle. And they then get these kind of comments from their leadership. What do you expect them to do when they deal with the Palestinians, who are seen and understood by their political leaders as human animals? So this is the challenge we are faced with. Now going back then to what also Dr. Professor Dube has mentioned, there are two aspects in terms of conduct of military operations. When Germany was bombed by the Allies in the Second World War, you can imagine what happened. When you go to Hiroshima and Nagasaki, you can understand what happened. When you go to North Vietnam, bombed by the US Air Force, you can understand what happened. So out of that experience, then there was a problem with regards to fighting in built-up areas, which is the urban warfare. And that raised a question, how, from a military perspective, do you conduct this? Because within that context, you will find those who are not fighting, you will find civilians, you will find children. And how do you deal with certain facilities like hospitals, like schools? How do you deal with residential areas? Now that speaks to the means and methods of conducting warfare. Means and methods of conducting warfare. So what kind of weapon platforms do you apply? When you do targeting, okay, let me just unpack the targeting part of it. When you see that that's a potential military objective to be attacked, then you need to analyze it. Why are you saying, as a commander on the ground, why are you saying that it should be attacked? And of course, people like Hamas or non-state actors would use those kind of facilities. They would hide behind civilians. They will do all sorts of those things. Now the question in terms not only proportionality, in analyzing that target, then you've got to also come look at the issues. How many civilians are there? How many children are there? How many old people are there? And then, if you must deal with that target from a military perspective, then you must make a choice in terms of the inventory you have. As far as weapon platforms, you must select. Are you going to use the Air Force to bomb from the skies? Are you going to use artillery to bomb from a distance? Are you going to use the mortar guys to throw some indirect fire support? Or are you going to select specialized units to go on the ground and deal with the problem on the ground, where you minimize the number of casualties, which is called collateral damage? So those are the issues. In this case, we need to say, have the Israel Defense Force, in terms of their strategies, in terms of their doctrine, and pre-deployment training, in fact, factored in the rules of engagement. Now, those rules of engagement will also be informed by what we Professor Dube refers to as international humanitarian law, which we also, as a subset of that, we've got what we call the law of armed conflict. It is there, not only for the Israel Defense Force, for everybody who wears uniform. When you go into the battlefield, then you need to understand what the law of armed conflict says in this case, and then you need to apply it. But we need to say, have that been observed? Have that been applied? Are there any rules of engagement in place? Has the military been trained so that at least they can apply them? That is up to us to look at that. Now, when you look at the issue of the right to protect yourself, which the Israelis right, you can go back to South Africa, because there's similarities between the two countries, especially during the time of apartheid. You will find that those who might have at least understand what was happening when the ANC MK was all over Southern Africa. You'd go to Lesotho, there'll be what ANC would call Maseru massacre. The SADF apartheid government would call it Maseru raid. It's the same in Matola in Mozambique. It's the same in Gaborone, Botswana. Now, what strategies were they using in terms of self-defense? They were applying what they understand to be preemptive strike, because it's about preservation of themselves. Therefore, if they think they know something is being planned somewhere, nothing will stop them to go beyond their borders, violate somebody else's space, do what they feel is right for them. And in the process, in all the cases I've quoted for South Africa, you will realize that the citizens of Lesotho, Mozambique, Botswana have suffered. They were killed in the process. So going back then to what's happening, then you will see a similar thing in terms of the civilians. Now, the statements mentioned by some of the Minister of Defense, the President of Israel, and of course the Minister of Energy and Infrastructure, when they take a decision to deny the population of Gaza water, food, fuel, what does that mean if you are not in the process of killing everybody in that area? And this has been going on for 4 months. And now they've been pushed all the way from the north of Gaza, center of Gaza, right to the south of Gaza, with the border with Egypt. And there is talk about attacking Rafah. Now what's going to happen there? Because now the people who are internally displaced have moved to that area. And of course, when they were moving, they were only moving with what they have in themselves and their children. And all their belongings have been left behind. If you look at the issue of the infrastructure, which has been destroyed, and if you look at certain hospitals which are being targeted, then the questions of the rules of engagement then also is what we need to question with regards to what's happening there. Accept responsibility to protect yourself. You've also a responsibility to protect the civilians, whether they are your civilians or the civilians on the other side of the equation. Now, here, there's an absence of that as far as Israel is concerned. So, for me, I think we need to question the military professionalism of the Israeli Defense Force, and also the statements and utterances of their political leadership in framing the situation of how the military conduct itself there. And of course, not exonerate Hamas in terms of what they've been involved in. But again, you are dealing here with the issue of asymmetric war, meaning there are those who've got all the means at their disposal and those who have got very little at their disposal, but they've got to survive. So that balance becomes very critical. What might be the influence of this in terms of the future? Well, it's quite clear when it comes to the issue of responsibility, junior officers are responsible for what's happening. But when it comes to the issue of accountability, senior officers and the general officers are accountable of what's happening there if you go to the issue of war crimes. And of course, utterances by the politicians might be also an issue to look at, which influence how the military conducts itself. For Israel, the impact going forward, they might lose some of their allies in the process. And of course, we are aware of what's happening in Egypt, Cairo, in terms of the negotiations, and we know the statements being made by their Prime Minister in terms of what he says should happen, in terms of that. For the USA, being at least the main supporter, then when it comes to the issue of humanity, when it comes to the issue of at least law of armed conflict, international humanitarian law, then there's going to be a question, where do they stand in all this? For Hamas, I think there is a lot of challenge. They've done what they think is in their right, but again, is that justifiable? To that extent, they still have hostages on their side. Israel, they are faced with a situation where the families of those who are hostages, with regards to the government taking the position they're taking, they might lose the present government the support of some of the families within the Israel context, because they believe the approach being adopted is not in their interest, especially when it speaks to those who are hostages held by Hamas. And again, there's an incident where they tried to rescue some of the hostages. That's Israel Defense Force. But in the process, they killed them. So you can understand from the population of Israel that professionalism where you go in and try and save, but in the process you kill the people supposed to be. So there is pressure on their side from within, and which might lead to the change of government. For us in South Africa, the position we've taken, and of course, in Congress in the US, there's a bill which is going on as we speak, and that bill might speak to, are we really non-aligned? And there is a view that we are not. And in the light of that, from a political economic perspective, we might also face some music. But of course, if we take a bold decision we've taken, I suppose we expect it, we understand what it means. So it's a very courageous position for South Africa, but it's a challenge for the Defense Force of Israel in terms of rules of engagement, and there's question mark in their professionalism. Dr. Nobe, thank you very much. I hope I've not tried.
To our retired Lieutenant General Baba Mqwebi, thank you so much for yet another interesting flip side of the coin with regards to the topic of the day. Colleagues, may I employ you to switch off your speakers and mute your microphones? Thank you. Allow me, colleagues, to introduce from the University of Johannesburg, Professor Martha Bradley, who will further elaborate on the topic of the day and give us new, interesting perspectives. Thank you, Prof.
I'm quite tall, so I hope that you can hear me. Good morning, colleagues. It is an honor to be here at Unisa. The reason being that when I was still a PhD student, it was indeed Morale's marking contract that helped me pay for my PhD studies. So I am in debt to Unisa, indebted. And that is why I'm so happy to support you, because those marking jobs really make a huge difference for those of us whose early career or studying. So thank you so much for that. I also want to applaud the Military Law Project. I think that is so essential for our own continent. My own work focuses mostly on organized armed groups and classification on the African continent specifically, and You know, unfortunately, the vast majority of non-international armed conflicts is on our continent. So I'm so happy to hear that Unisa is onboarding this project, which is of seminal importance. General, thank you for sharing your wealth of operational experience. It is always wonderful to hear from operators who's actually been on the ground. And I look forward to elaborating from a textual IHL lawyer's perspective. I really want to thank the organizers, specifically Professor Dube, for including me in such a distinguished and diverse panel. I think it's very important to hear all aspects, from military law to operators who has that practical experience, and also for the gender inclusivity of having a female lawyer on your panel. So thank you for that. As I'm not a woman of a few words, I do have text. Otherwise, you will go well into lunchtime. My area of speciality is the law of non-international armed conflict, or IHL of NIAC. So if I do use NIAC, please forgive me. It is the practitioner's sin. It is for non-international armed conflict. I am therefore focusing the aspects of my presentation of the order in relation to the case of the application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israel, to request for indication of provisional measures on what I know, which is IHL. Indeed, South Africa did not raise IHL specifically, so you might think, what is she on about? You know, speaking about IHL in a case concerned with the Genocide Convention. IHL, however, as you heard from the General as well, remains very, very relevant. And it was flagged by the court in its order, and I cite the relevant part. The court deems it necessary to emphasize that all parties to the conflict in Gaza Strip are bound by international humanitarian law. And I just want to repeat that. The court deems it necessary to emphasize that all parties to the conflict in the Gaza Strip, all parties, are bound by international humanitarian law. It is gravely concerned about the fate of the hostages abducted during the attack on Israel on 7 October 2023, and held since then by Hamas and other armed groups. Interesting, right? By Hamas and other armed groups, and calls for their immediate and unconditional release. So this paragraph, for me, is noteworthy for various reasons, and I single out 3 specific reasons. First, the case brought by South Africa made no mention of IHL, but turned on the content and jurisdiction provided by the Genocide Convention. This was for good reason, as if we didn't bring up and vested ourselves and relied on the Genocide Convention, the case would have been inadmissible. Second, the court's ruling are only binding on states, not non-state armed groups. Yet, it did remind both parties, including Hamas and its allies, that IHL is the applicable legal framework in Gaza. Third, using the wording Hamas and other armed groups may speak to the court's understanding of the situation as being non-international in nature. And this is fascinating, as various scholars argue that no, the law of international armed conflict applies because of occupation, or Hamas is a non-state actor, so we apply the law of non-international armed conflict. Essentially, classification does not matter that much in this case, except for humanitarian relief. Why? Because as the General indicated, the first principles of IHL always apply, regardless of classification. Personally, I want to applaud the ICJ for going this far, for going beyond the issue of genocide raised before it. It went beyond South Africa's application to acknowledge the application of IHL, which determines both how urban warfare should be fought and the regulation of humanitarian access and relief. I must stress that this pronouncement by the ICJ is not legally binding on Hamas as a non-state party to the conflict, but IHL certainly is. Common Article 3 is binding on non-state armed groups as well as states equally. But this paragraph is indeed a bold gesture by the ICJ, and perhaps it urges Israel to really consider the laws of conduct of hostilities for those monthly reports, which is also significant because in the 3 instances that the court has provided provisional measures in terms of genocide cases where perhaps genocide might be committed at the provisional measure phase, it was only one time that they asked for periodical reporting, and then in the other instance of Russia and Ukraine, they didn't ask for reporting. So asking for a monthly report really shows that the court deems the situation as very, very serious. I wish to reflect on the rules of urban warfare and its complexity, which the General has sketched in a much better way than I could ever can, thanks to his experience. Israel specifically, in its response to South Africa's application, dare I say, employed, and this is my own interpretation, employed urban warfare as a defense, that it was not committing acts of genocide, and rather that the destruction on the ground and the injury and the death toll was a consequence of urban warfare. And I think this is probably what we might see at the merit stage. I will consider the situation in Gaza up to the date of the hearing, as this did not include the situation in Rafah this past week. I will briefly reflect on South Africa's urgent application brought 2 days ago in respect of Rafah, as this is a separate situation before the court. I now turn to cite the opening lines of paragraph 40 of the order dated 26 January 2024. This was the order for provisional measures. And I read, Israel submits that the appropriate legal framework for the conflict in Gaza is that of international humanitarian law and not the Genocide Convention. Of course, they were trying to refute that the court has jurisdiction. It argues that in situations of urban warfare, civilian casualties may be an unintended consequence of lawful use of force against military objects and do not constitute genocidal acts. Israel considers that South Africa has misrepresented the facts on the ground and observes that its efforts to mitigate harm when conducting operations and to alleviate hardship and suffering through humanitarian activities in Gaza serve to dispel, or at the very least, militate against any allegation of genocidal intent. End of quote. For the sake of clarity, urban warfare refers to the type of conflict fought in cities and urban areas. The reality in these scenarios is that civilian buildings and protected sites are often in close proximity to military objectives or targets, as the general has also sketched. And this is not only the situation in Gaza. Unfortunately, the situation in Sudan is often overlooked in Western media, but in Khartoum, civilians are suffering a very similar fate than what is currently ongoing, because indeed the two parties to that conflict, the paramilitary group and the army, is engaging in urban warfare in the capital of Sudan. In its 12 issues for 2022 report, the ICRC, the International Committee of the Red Cross, which is often referred to as the custodian of IHL, flagged the challenges posed by urban warfare concerning compliance by parties to IHL. The ICRC stresses that, and I quote, the humanitarian consequences of urban warfare are complex, direct and indirect, immediate and long-term, visible and invisible, and call for a more sustained and holistic humanitarian response, end of quote. Unfortunately, this is not what has been transpiring in Gaza. The ICRC echoes that urban fighting causes extensive destruction of and damage to critical infrastructure required for the delivery of essential services such as electricity, health, education, water, and sanitation. You have seen on the television coverage that at many stages there was but an hour of fuel left in the generators that was supporting electricity for hospitals. So it's unfortunate that this reality is the lived reality for civilians in Gaza. Even though urban warfare challenges the means and methods of warfare, that is, weapons selection and how parties engage each other on the urban battlefield, IHL and its basic principles continues to apply. And I want to stress this, whether you find yourself fighting in a city or not, IHL continues to apply. This is not negotiable to either party to the conflict. The reality of urban warfare, in my view, and General, it will be interesting to hear your practical views since you've lived this, is that it demands greater care on both parties to the conflict in ensuring compliance with the basic principles of IHL, meaning that when you are designing your military operations or planning your attacks, there is a greater emphasis on precaution because of the reality of the urban setting. I wish to stress that the basic principles of IHL also applies in non-international armed conflict. As the ICRC stresses, protecting civilians caught in the midst of urban combats starts with full and good faith compliance with IHL. None of this is disputed in law. I would like to refresh the audience specifically on the definitions of the principle of distinction and proportionality. And thankfully, the General sketched a nice picture of how that looks in reality. But as a textualist, you know my work, I'm a textualist, I always like a definition, also for those in the audience who's not IHL lawyers. The principle of distinction discriminates between legitimate military objectives, which may be targeted, and civilian objects, which may not be targeted. Two categories of distinction are required for this principle to be fulfilled. And yes, I see some faces in the audience that looks baffled, probably from what you've been seeing in the Ukraine-Russia coverage and the Gaza coverage. Your attack may not specifically be directed at civilians or civilian infrastructure. First, the category of parties to the conflict is important. A distinction is made between combatants. This means, for example, members of the IDF, the Israeli Defense Force, and the fighting members of Hamas, who can be targeted directly. But civilians may not be targeted directly. Secondly, we have the category of property. There is a distinction between civilian property and property which may be considered a military objective. So as per Article 52 of Additional Protocol 1, objects are military objects if they, quote, by their nature, location, purpose, or use, make an effective contribution to military action and total or partial destruction, capture, or neutralization in the circumstances ruling at the time offers a definite military advantage. Civilian objects, on the other hand, are all those objects which is not military in nature. This means that civilian apartment blocks, for example, may not be directly targeted, whilst Hamas's headquarters or armory may be targeted. It is important to also flag the reality of dual usage. And General, you pointed to this, that when we have war in cities, it becomes more complicated because, indeed, armed groups may use formerly civilian apartment blocks for their headquarters, which changes the nature and status, then making that apartment block targetable. A protected infrastructure, such as a hospital or school, loses its protection if it is used for military purposes. For example, if weapons are stockpiled in a hospital, then the hospital loses protection. This, and I want to emphasize this, however, does not mean that it is a free-for-all card to bomb that hospital. Together with the principle of distinction is the principle of proportionality. So I want to stress that even if and when an object becomes targetable, even if and when there is a tunnel underneath a hospital and a stockpile of weapons for Hamas, the proportionality principle does remain relevant. Application of the proportionality principle is trickier than that of distinction, and I am thankful that I am just a humble IHL scholar and, like the General, do not need to make these tough decisions on the ground. But proportionality demands that the collateral damage that results from the attack must not exceed the military advantage anticipated. And you can see why this is difficult. It's a very vague construction, right? You need all the intelligence to understand if the decision-making process actually considered the collateral damage and if that military advantage was so important to take the route. As Mike Schmidt observes, and I quote, "Of all the rules regarding the conduct of hostilities, it is the vaguest, and therefore the most difficult to apply by those in the field or during post-factum assessments of an attack's lawfulness." And I'm sure this is something which the International Criminal Court will also struggle with. Often in the reports provided by the IDF, it claims that Hamas is using hospitals to stockpile weapons and as tunnels beneath civilian infrastructure. This changes the nature of the infrastructure from civilian to military. However, the proportionality principle limits the nature of attack in that a collateral damage assessment must be made. In terms of this principle, it's more an assessment or a principle of means, of military capacity, and therefore it's my view that in this case more can be expected of the Israeli Defense Force, as they are one of the most sophisticated defense forces in the world with access to highly sophisticated precision weaponry. Therefore, it could be expected that precision weaponry is employed that causes the least amount of collateral damage. If you can, send in a sniper or ground forces instead of bombing infrastructure, knowing the civilian collateral damage. This is essentially what this principle demands from us. Evidence of IHL compliance in urban warfare is made more complicated by the fog of war. It is difficult, very difficult. We all read in the order that there must be no tampering with evidence, right? But how difficult is it not to attribute death count? If Hamas and the IDF are fighting in close proximity, how do you know to attribute that dead body or that injured person to a specific party to the conflict? Whilst urban warfare may have been to some extent a defense, and I use defense in brackets, by Israel to argue that the Genocide Convention is not applicable, but rather the Geneva Conventions, it is very difficult to imagine how this line of argument could be employed in response to South Africa's application concerning military operations launched in Rafah. And this is where I give my final thoughts. On 12 February 2024, South Africa made an urgent request to the ICJ for additional measures concerning the situation in Rafah. Article 75(1) of the ICJ statute does enable South Africa to bring such an urgent request. Rafah is essentially, in my view, a refugee epicenter. On 11 February, the IDF launched a military operation to retrieve 2 hostages in Rafah. The operation, however, resulted in the death of 67 people and approximately 100 people were injured. The military operations in Rafah clearly do not comply, in my view, with the principle of proportionality. And it will be a stretch for the IDF to justify these actions based on the fog of urban warfare, because they're now operating in Rafah. Again, I must use the disclaimer that I am not privy to confidential information, and like most of us in this room, I'm making use of reports in the media and so forth. The linkage made to urban warfare here is essentially owed to the narrative used by Israel in their oral pleadings that IHL is applicable. And yes, IHL is applicable because we do have a conflict, but that does not mean that the Genocide Convention is not applicable. So in response, the court did remind both parties that they are bound by IHL. In my view, the military operations launched in Rafah by the IDF are ignorant to this plea by the ICJ. Thank you for this opportunity to share my thoughts. Thank you.
Thank you, Prof. Martha Bradley. At this juncture, allow me, colleagues, to call upon Ms. Michelle Panache-Zororo, who is an ULSA representative, to ascend to the podium and give us another side of the talk.
Good morning. everyone is doing well. All protocols observed. I'm a bit nervous. I shall not really go into the prospects of the ICJ case because I believe the previous speakers have done it justice. And I'm pretty sure we all have an understanding of what is going on. The ICJ's involvement in the Gaza conflict has had significant legal and diplomatic implications. And South Africa's case against Israel, accusing it of violating the Genocide Convention, has led to the ICJ ordering Israel to take measures to prevent genocidal acts and protect the Palestinians in Gaza. This ruling has increased international pressure for a ceasefire and has the potential to impact Israel's global standing. This decision, while not finding Israel guilty of genocide, brought the plight of Gazans onto the international stage, potentially galvanizing the stronger political power for ending the conflict. And as I mentioned, this ruling has had several significant diplomatic implications, which I'll be getting into. But before that, it may be important to mention that this ruling has not resulted in an immediate ceasefire, but it has placed legal obligations on Israel to prevent genocide and to report on its actions. The decision has been criticized by Israel, which maintains that it is fighting a legitimate war against the Hamas, but it has also been welcomed by human rights activists and organizations, as well as some international leaders, well, most international leaders. And despite this ruling, Israel has intensified its military operations in Gaza, and reports suggest escalated violence and increased civilian casualties each day. This begs the question, what is the significance of the ruling if it is not bringing any change? Now back to the diplomatic implications. My paper will be based on the diplomatic implications of this ruling. The ruling has also highlighted the importance of international law in preventing genocide and protecting civilians, but there are potential diplomatic implications, like Israel could be isolated from the rest of the world. The ruling has sort of placed Israel in a very difficult diplomatic position, as it has now been criticized by human rights organizations and some international leaders for genocide. We have the judge from Uganda who is now the talk of every nation because she was against what everyone else believed to be right. This isolation could make it more difficult for Israel to secure support from its international allies, such as the United States. And this decision could pose a dilemma for the United States, as it has traditionally always supported Israel. And we know that they are still supporting Israel. If the UN Security Council passes a resolution requiring Israel to abide by the ICJ's orders, the US could face a difficult decision about whether to use its veto power, which could damage its relationship with other UN member states. These actions will be subject to increased scrutiny by international organizations like mentioned, and the global community as a whole, which we are already seeing. And now there's increased pressure on Israel to comply with international law and to take measures to prevent these genocidal acts and to protect civilians. The pressure could lead to increased scrutiny. There's also a chance that the security alliances of Israel could be challenged. Like I mentioned, the United States is now in a very difficult position when they are trying to support Israel. And then there's also challenges for the Palestinians who are at the heart of this. Because this ruling has actually put them in more danger than they were before. If we look at the increased number of reports, and then the South African government itself also faces a bit of a challenge because, first of all, they have not released the budgets that they used for this case. And one can imagine that millions went into that. And we look at the unemployment rate being at 42%. We look at a lot of social economic issues that we're going through, and yet they are choosing to play hero on the global stage. That's how it all seems to some. And maybe to me, but yes. So that is a challenge, but it is still important that this genocidal act stop, and perhaps someone needed to say something. Regardless of the resources needed, I believe no resources are more important than human life itself. But now, if Israel does not comply with the ICJ orders in Gaza, this could lead to a loss of credibility and trust in the order of international law. Like I mentioned, what use is a judgment if it is not making any change? The ICJ's decision to compel Israel and the broader Genocide Convention and Geneva Conventions, they will all be questioned. And Amnesty International Law has warned that the failure to comply with the ICJ's ruling could lead to a risk of genocide in Gaza due to the high death toll among Palestinians, the widespread destruction caused by Israel's bombardment, and the deliberate denial of human aid. Now, so many more lives are in danger. Food can't go into Gaza, and lives are being lost. But I believe it was essential for South Africa to speak up, because if they didn't, then who would have? At the same time, what implications are there for the world as a whole? Is this a road to us going into another world war? Or is this just the beginning to an end of this to an end to these attacks? I just hope that the world can come together and be able to save lives beyond political needs and everything else involved. My paper is still in construction, but it will be on the diplomatic implications of this ICJ ruling. Thank you.
Thank you, Ms. Zororo, for your valuable contribution to today's deliberations. Allow me to call upon representatives from various Unisa journals. Present today, we'll have a representative from the South African Yearbook of International Law and the Comparative and International Law Journal of Southern Africa. Colleagues who are representing these journals, please come through in that order. Thank you.
Good morning, colleagues. Good morning to all of you in presence here in person, as well as to our online community. My name is Steadily. I am a journal editor for the South African Yearbook of International Law, and I'm also the acting chair of Department of the Public, Constitutional and International Law Department. Let me just start by observing protocol and thanking everyone who made time out of their mornings to come and present, to participate, and just to honor the invite. And Prof. Dube will know I'm quite partial to the young ones, the students participating in these occasions. And I got such joy when Ms. Michelle Zororo said that her paper is still under construction, because even at a young age that she's at, just coming out of the law academic study, she's already preparing towards publishing a paper. Prof. Dube and I were charged with international moot courts, I think 3 years ago. And a gentleman who is now the cameraman was, there we go, Tendani at the back. He was a participant in that moot court. And one of the requirements Prof. Dube and I, spelled out for all of them is that you can't just participate in moot court and just, lay back after that. You need to participate in a meaningful and substantive manner, both in the academic and social scene of law. So I'm proud to say that the young ones, including Tendani and my own mentee, Utando Lwakhe Mokotedi, who's a master's student at the Potch University, have submitted some articles for publication. So a round of applause for that. And I encourage everyone else who's here this morning, young and old, to consider contributing towards this conversation in a publication form, please. Be it a conference proceeding, a case note, a reflection, or an article, or anything like that. So just to get on with the business, so I'm here to speak about the South African Yearbook of International Law. Again, I'm a section editor within the journal. So just to offer you some context, with the focus and scope of the journal. So the South African Yearbook of International Law, SAIL for short, is an annual publication published by the Unisa Press and administered by Unisa's Department of Public, Constitutional and International Law Department. SAIL is accredited by the Department of Higher Education and Training of South Africa. This yearbook also publishes contributions in English in any areas of international law. So the Gaza debacle is a perfect example of a researchable topic for publication within the journal. We encourage articles, case notes on current issues, and those that look back on the developments that took place during the year of the volume. So although we publish articles in any area of international law, the editors particularly welcome submissions which have a South African interpretive angle. So we always try to bring in an element of applying the issue, of course, within the global stage, but bring into, the South African context, just to maintain that applicability, So yeah. So with regards to the peer review process, all submissions are peer reviewed by means of a double-blind system to guarantee impartiality and a focus on the quality of the submissions. All articles submitted to the journal are peer reviewed by at least 2 reviewers. The final decision in case of a dispute between the reviewers lies with the editors, although in all cases an attempt is made to reach some kind of consensus between the reviewers. Of course, you'll be interested about the editorial policy. So it's quite long and lengthy and informative on the website. It includes all the technicalities and other, pertinent information. So I do invite you, if you are interested, which I'm sure you are, to publish with SAIL, to go onto the website, just read on the particulars, but I'll just skim through some of the important information. So contributions that have been published in part or in whole elsewhere or sent for consideration elsewhere will not be processed. Contributions are subject to plagiarism check using Authenticate. The journal will not publish submissions by the same author in consecutive volumes. So should the author still wish to submit, a 1-year waiting period will always apply before the article can be considered for publication. And the final decision to publish contributions resides with the editor. In case of a dispute, authors may approach the chair of the editorial board. So I would like to make an expression with regards to the latest edition that we have. So for the volume 48, which was the 2020, which was allocated for the 2023 year, we published a theme section containing papers from our 2022 conference, and we're also now working towards our 2024 volume to contain papers from our 2023 conference. So it operates just 1 year back. But please, again, I invite all academics, both here present this morning and those in our online community, to consider handing in, case notes, reflections, book chapters, or journals for publication in the area of international law, of course, with a specific angle to South Africa. Thank you very much, Chair.
Thank you very much, Mr. Sigelela Ndlazi. Would like to call upon next a representative of the journal, Comparative and International Law Journal of Southern Africa.
Good morning once again, colleagues. Yeah, it is still morning. Good morning. Here I'm just going to talk quickly about the Comparative and International Law Journal. We are an international journal. We are IBSS Scopus accredited, and which is more reason for you to actually consider publishing with us. We publish 3 issues per year, and we are currently finalizing the first issue of 2024. It's actually in production, and we have about 3 papers for issue 2 of 2024. So if you are considering publishing with us, you need to submit your manuscript as soon as possible. And in the journal, we do consider book chapters, we do consider book reviews, we consider opinion pieces, articles, and book reviews. In terms of the articles, they need to at least be between 8,000 and 12,000 words. Our case notes should be between 4,000 and 6,000 words. Book reviews and the rest are supposed to be just between 1.5 and 3,000 words. We use Oscola, and it is important. I'm sure those who have submitted their papers there, they have received an email from me saying that they haven't complied with Oscola. So it is important to actually respect the journal's house style. And within the team, we have 6 people who are part of the editorial team. I'm the chief editor, and we have Mr. Mukomane from Unisa. We have Dr. Swikani Ngube from University of Johannesburg. Yes, he's from there, pardon me. And then we also have Ms. Mansha Mohe, who is from the African Development Bank Group in Cote d'Ivoire. And then our program director, Dr. Ngube, just joined the team. And we also have 7 board members within the team who oversee, as Mr. Ndlazi indicated, appeals and other things. But in terms of the day-to-day running of the journal, this is the team that oversee the process And I'm not going to speak to the requirements because Mr. Ndlazi has already touched on those. Those are the requirements from DHAT, and SILSA also respect those. And we also do a double-blind peer review. We try to look for a peer person to actually have a look at some of our manuscripts, especially if we have manuscripts from emerging scholars. We try to get one established reviewer and one emerging scholar, just so we have a balance, and to try and stick to that peer review process. And our turnaround time is usually around 4 to 7, 8 months, depending on, as some might know, reviewers, because sometimes you do have to follow up. But yeah, generally that's the turnaround time for the journal. And in terms of the topics, we look at anything international law, but because it's a comparative journal, so if it's something that is outside international law, it has to be a comparative study. And we are strict on that. If it's international law, it doesn't matter which field of international law we accept it. But if it's pardon me, if it's a comparative study, we do look out for those comparative elements so that we do not lose our international recognition as a journal. And then we would appreciate if you could consider, especially the speakers, submitting some of the, even if it's an opinion piece, 1,500 words to 3,000, and just throw it there. And we currently are also busy with a special issue. Some of you might know that the Unisa College of Law hosted the African Bar Association annual conference last year. And from that conference, SILSA was identified as a journal that was going to publish the special issue from that particular conference. So we are looking forward to that, and please do subscribe. We do have subscription for the journal. It really supports us financially, especially because we do not charge page fees. So it is important that you subscribe for the journal so that we are able to publish, and we publish with Unisa Press. In fact, all the journals within the College of Law publishes with Unisa Press. So we do pay for the publication and page fees, and for that reason, we would like to have your subscriptions. And if you are interested, you can just go to Google and type Comparative and International Law Journal of Southern Africa. And you don't click on Sabinet, you click on the Unisa Press, because we now, like I said, publish with Unisa Press. And with that, I'm looking forward to receiving your papers. Thank you so much.
Thank you, Dr. Mhlongo, for that piece. Colleagues, pardon me for introducing Mr. Tendani Msekwa. He's not on the program, but we saw it fit to include him here as he has something to share with us concerning the African Peer Growth Network, which is one of the initiatives which the College of Law seeks to cultivate and help share a peer-to-peer growth network, as the name suggests. So colleagues, allow me to welcome to the stage Mr. Tendani Rico Musekwa, who is from the Public, Constitutional and International Law Department of the College of Law of the University of South Africa. Mr. Tendani, the floor is yours, sir. Thank you.
Good morning, colleagues. Thank you very much, Program Director, for affording us an opportunity to interact and further interface with people of this high standard. We love the podium, some of us. See, when you're speaking these issues, we want to run and come and join you. So I am just here to speak about, I'll just give a little bit of the African Peer Growth Network. As the program director seems to be interested in me speaking about it, but initially I'm supposed to speak about the blog that the African Peer Growth Network it's running. So colleagues, let me just give a little bit of our story. I will not go much into detail because I am here to speak about the blog, but this African Peer Growth Network is one of the organizations that exists, which has been in partnership with the University of South Africa on a multiple number of occasions. I'm here to speak about the blog, but I need to introduce you to this organization. I'm sorry, you will pardon me for that, but you need to know about this organization. So just a brief introduction of this organization. So the African Peer Growth Network is a registered non-profit company, which it is headquartered in South Africa, Johannesburg. The organization is women-led and brings together a vibrant team of African researchers from diverse disciplines, including law, business, and aviation. When I speak about this aviation, I do not want to go much into details, but the reality of the matter is that there is a lack of participation from the majority of young people in that space. It is very much neglected. And we've got our CEO, Professor Angelo Dube, whom is an aviator and a qualified pilot. So we do not close doors towards the prosperity of any young person. If you are interested, it's never too late. It is not magical to become a pilot. I mean, it is magical because there is effort that needs to be put in, but in terms of the process, people, young people, especially the black marginalized, they would think that it is undoable, it is unbelievable, and all those things. However, it is very much doable. You can speak to Professor Angelo Dube, the CEO, and a pilot, and a qualified pilot, by the way. Let me put it abundantly clear. You can approach him. He can be able to assist in those regards and pave a way and guidance as to how do you become. So we have a blog as the African Peer Growth Network. I was just giving a brief introduction. So this blog of the African Peer Growth Network, it publishes ideas which speaks to decolonization, speaks to aviation, it speaks to philosophy, it speaks to, it's a multidisciplinary blog. So it does not restrict you to speaking to a particular field and not have reflections on the other fields. So the aim of this blog is to improve research capacity. So this is an outlook of the blog and also an outlook of the organization at large. We don't only focus on already established academias, but also upcoming young emerging researchers. So you would not be shocked if tomorrow in the African Peer Growth Network blog, a grade 9 has published an article. We are clear like that. We don't close the doors. We open the doors to everyone. So we improve research capacity in Africa, and we increase Africa's contribution to global research outputs. So we need diverse knowledge systems. We need contributions from various schools of discipline. Does not matter the age, by the way, as I have said. Everyone is welcome to publish in our blog and make a contribution, because there's no information. We believe that there's no information that is useless. Each and every information, whether it's coming from a young person or an established researcher, we welcome it and we embrace it. Where we see the need for it to be polished, we've got professors, we've got doctors, we've got emerging researchers. They will assist in that particular development. So the blog also aims to increase research in areas that have a direct impact on the lives of Africans. So in other words, we promote solution-orientated research. So it is not stringent on the number of words we require for one to publish in our blog, by the way. It is 800 to 1,000 words. So you can just sit here and have a thought and just type it now and send it to us. It will be evaluated, of course, it will be corrected somewhere, somehow, and then it will be brought back to you with comments, and then you will fix, and then it shall be published in our blog. So in 2022, we had a conference. It was our first annual conference it was the second in actual fact. We first had one in the University of Western Cape. We produced a number, we were in partnership. So I want to show you that this blog of ours, it is very much active and it is running. With the University of Western Cape, we had a conference where we had research outputs which are going through publications. Sahil and Silsa, they also, where we need to outsource, we outsource. So same applies to the one that we had last year. We had a second annual conference in partnership this time with the University of South Africa, right? So we have had two annual conferences in partnership with the University of South Africa. And we would like to thank them very much as an organization for the support that they have given us in transforming the life of an African child. We are having also exciting news, colleagues, because we are an organization of movers. We don't stop in one place. We are not stagnant. We move with speed. It's either you catch the train or you remain in the train station. So we are going to be having another annual conference, by the way. We are going to have an annual conference in Paro Campus, Cape Town. We have opened the call for papers. You don't have to be a professor. You don't have to be an academia who is already established. You just need to be a person with thoughts. We have opened the call for papers. You can just check on our blog. That information shall be updated as to when is the due date of submission, but it's already there. I think we distributed it last, or when we were closing the conference last year, because we plan ahead of time. We are young with age, but in terms of thinking, we are very old. We are already at the age of 40 now, while we are 20-something, some of us. So we are planning ahead of time. So we had a call for papers, which was distributed, and we have opened it now. So from the 18th to the 20th of September 2024, the annual conference of the African Peer Growth in partnership with the University of South Africa is taking place. Be there or be told. But I want you guys to be there so that we are able to transform the knowledge system and be able to develop each other's thinking without having to undermine each other. Who knows? I don't think us as professors here, as established scholars, we want to be professors alone. Even me, I want to be a professor. Is it wrong for me to want to be a professor? Adopt me, colleagues, and teach me. So you might find your own mentee, and then you start mentoring from that, because that's what we seek to achieve. As this blog is there, that's why we say we do not only take, we don't select. We want everyone to have an opinion. I think that's how we will be able to build a prosperous African continent and also decolonize the European continent as well. Because they take this knowledge from us, they don't want to acknowledge it as such, and then they want to come and impose it in their own way. So we are an Ubuntu-driven, comrades. Hey, I'm sorry, man, student politics have entered my head too much. I'm even calling you comrades. So we are an Ubuntu-driven. So that's, I just wanted to give that insight about our blog. I might not have said enough, but I introduced you to the organization. I've introduced you to the blog, its aim and objectives, what it seeks to achieve, the number of ways that it seeks to, that it requires. And we only need 5 references. 5. It's not like, you know, when you're writing these things of masters, now you must have 70, what there in the referencing. So here we just need 5 colleagues. I'm very much grateful for this opportunity. My name is Enakrire Msekwa. I had not introduced myself, but I'm going to do that now as I leave the podium. I am Enakrire Msekwa, a student assistant in the College of Law. I am also the Human Rights Officer of the African Peer Growth Network. And I'm very much thankful for this opportunity, colleagues. Thank you.
Many thanks to Mr. Enakrire Msekwa for giving us an update on the UPCGRON. I think it is quite imperative, especially for young and emerging scholars, students, to be in such networks in order to be groomed by experts, which I see are part of the UPCGRON in this field of academia. And also it is not solely for students and academics. Even people outside the academic space are also welcome in the UPCGRON to come and share their views and African perspectives on contemporary issues and pertinent issues which affect every facet of us as human beings. Colleagues, now it is that time where we open up the discussion to the floor, those who have attended in person and to also our online community. But before that, may I kindly implore you to give us a round of applause for our team of speakers who have given us thorough deliberations on today's topic. Thank you for that. May I also ask our panel of speakers to ascend the stage to the seats on my right for the Q&A session, so that when we ask and require responses from you, we can clearly see you and interact accordingly. While our speakers are still ascending to the stage, in no order of importance, colleagues, this is the time now to open up the conversation to the rest of the floor and as well as our online community. I saw already in the chat that there are a number of comments and questions which have been asked there in the chat. I'm sorry, colleagues, we are looking for the roving mic for our physical attendees. Yes, I was saying in no order of importance, we're now allowing questions, comments, suggestions, and any input from the floor at large. I will start with the questions that I saw in the chat and comments. I saw Advocate Nandipa to be in the room, but I can't see her right now. Oh, there she is. Advocate Nandipa, you may go ahead and ask your questions and go forward with your comments and suggestions and so forth. There is a roaming mic. Thank you.
To the University of South Africa, and specifically to the Faculty of Law, the Dean, Executive Deans, the Directors, the CODs, and all the management and the colleagues, we are very grateful for the session. To the University of Johannesburg / University of Pretoria, the alumni, we are very thankful for this session. And of course, the IHL being the IGLA domain, it's exciting to hear from you. To our own, in turn, we're proud of you. To the General, the pride of Africa, the owner of creating a better Africa, a safer Africa in a better world. I would want probably to check from you, Party Nkubo, if you want me to actually read the questions as you had instructed that you must dot our notes. How do you want me to progress with the questions? Should I read them or I give just an overview of the issues as they relate to each and every one of them?
I think Prof. Dube preached decolonizing everything, so I think do it as you would like, in the spirit of Ubuntu.
Let me decolonize the already colonized African international push. Prof, my question to you is an interesting one. I like when you say, when did we get civilized? But I want to throw the Ubuntology. Yesterday I was in another debate where we were talking about Ubuntology. The Ubuntology discourse, if it were to be introduced, what do you think would be the response, Prof? And triangulating that then with the recalibration agenda that we are insofar as the African perspective of international law. How do you see the level of acceptance insofar as where we went to as South Africa? To General, I want to just check in terms of the doctrine, the military doctrine. General, educate us in terms of the three layers of defense and as they apply to the two theaters, the Gaza theater and the Ukraine theater. What does this mean for Africa? And what does it mean for the construction of the military doctrine? We are here writing the introductory remarks to a military law course. What does it mean to that groundbreaking intro to that course? Because we want the African perspective. also general, noting that the target was the kibbutz system in Israel. And now talking to a veteran. The kibbutz system, by implication, is where social cohesion takes place. What could be the implications of the target insofar as the posture of the Israel military defense capability? Coming to my own alumni from University of Pretoria, ICLA, are we saying the current IHL, are we saying the current SOFAs, are we saying the current rules of engagement, are we saying the current doctrines have not encapsulated the war, the theaters, both urban and rural? We are in a military law construction course. And so we need to look at what the implications are of our presentations in terms of then the principles that must inform the various doctrines. To our own timber that we are concocting. The issue of protecting lives, does it have a cost? Thank you.
Thank you for that contribution. I think let's allow our panel of speakers to attend to those questions. Thereafter, we'll take other questions and go on. Prof, if you may.
Thank you, Program Director. Can I quickly recap? I couldn't get both questions that you posed. I think for the second one, I thought you said the level of Ubuntu acceptance, the level of acceptance of Ubuntu. Am I correct? Advocate, I didn't get both your questions, but for the last one, I think I heard you talk about the level of acceptance of Ubuntu. Yeah. I'm just trying to figure out if I'm correct there. Okay. Okay. Wonderful. Wonderful, wonderful. And your second one would then go to, if we push this narrative, is it going to be acceptable? Okay, I get you. Let me try and... I will do so. I will do so. Thank you, Advocate. When did we get civilized? Are we civilized yet? That was the title of what I was presenting. If one goes back to international law itself, if you're a scholar of international law and you were taught by Dugard, as he was my professor of international law back in the day, you will probably make the argument that international law is 500 years old. They taught us that because they were taught that as well. The Eurocentric University, the Eurocentric Center of Knowledge, said somewhere in Westphalia, the tribes of Europe decided to stop fighting. They had been fighting for 30 years. It was a civil war, one tribe killing the next tribe. You know, the tribes of Europe were fighting. But somewhere around 1648 in Westphalia, they came together and said, okay, tribes, we have lost enough tribesmen. Let's stop this barbaric thing. Let's come together and realize that you, state A, are sovereign, and you, state B, are also sovereign, and you're both equals. The claim, even Malcolm Shaw, that is loved by the West, will teach you that. He is stubborn to this day. He teaches that nonsense. At least Stugard, Henry Stridham, they have infused these elements into their texts. They've evolved with time as well. You know, they've embraced the decolonial aspect of international law. But Malcolm Shaw is stubborn, and he still insists on the Westphalian nonsense of the origins of international law. So they will tell you that it started in Westphalia because the North decided, let's stop fighting, let's now come and sign the Peace of Westphalia so that we can live together in harmony as states and use international relations to regulate our disputes, avoid war, and start using international law. They will claim war, international law was then born at that stage. In the early 1900s, when the Permanent Court of International Justice and the League of Nations were still in place, the idea was that there's the civilized self, which is the European. Then there's the barbaric other, which is the African, the Latino, the Asian. The laws that were to be accepted as generally applying were those of the civilized self, which was drawing from Roman law, drawing from the British customary law. The customary law of the British tribe was now regarded as a universal construct that binds you. Because you're barbaric, you need to be civilized through the instrument of colonialism. Colonialism was presented as an instrument of producing a better you. In fact, you must, in their minds, you must thank them for colonizing you. So at that stage, we were not regarded as civilized. Fast forward to Hitler's mess and the 1945, the creation of the UN and the creation of the ICJ as it stands today. The wording was still the same. General principles of law recognized by civilized nations. Me and you, we still belong to nations that were not regarded as states, despite having had governments, despite having had populations, despite being capable of international relations at the time. We're not state. We're the uncivilized other. We're the barbaric other. So even as the UN is created, even as the ICJ is created, we are still regarded as the barbaric other, you know, under the auspices of the civilized Europe at that moment. To this day, the wording of the statute has not changed. There are scholars who will argue that the statute must remain the same. It must still use the words civilized nations, but we must just change our understanding. We cannot. Because if you look at the architecture of the UN today, the permanent five, America sits there. Whatever Israel does, you cannot touch Israel. Whatever motion you want to move before the United Nations Security Council will be vetoed by America by simply not voting in favor of what you want. So how then does the UN Security Council get capacitated to carry out its mandate of maintaining international peace, including through the use of force? It is emasculated. It is castrated. It has no power because of the architecture of the United Nations. Put South Africa there as a permanent member of the United Nations Security Council. Do away with the veto power. Take away that, that baton that they've been wielding for so many years. So when were we civilized? We are not yet civilized. Until we take back the calibration of international law, until we take back the references to us and we drive the narrative through protection of scholarship as we do here today, we will remain the uncivilized other. Because our laws, our Ubuntu, are still judged by a law or a worldview of 1914, a worldview of 1902. The text has remained the same for over 100 years. General principles of law recognized by civilized nations. And in their words, you would not be. Sebitunda would have voted against the adoption of Ubuntu. I can tell you that. She would have said, no, Ubuntu has no application here. So how will it be accepted? We have to just keep pushing. If we can accept norms coming from customary law of the Romans, why can't we accept norms coming from the customary law of the Bapedi, the customary law of the Vatonga, the customary law of the Vavenda? Why can we not do that? Thank you.
If I may just add in, and I know the General has various questions, the ICRC is working on revising or adding to their African Values Project, which essentially serves to show that there are African values that even pre-existed, some of the first principles of IHL, such as distinction, protection of women, and so forth, and to get further buy-in from organized armed groups on the continent and so forth. So I think that it will be fascinating for them also, Angelo, if you write on Ubuntu as a concept, because I haven't seen Ubuntu in these values, but the relationship that it has to the principle of humanity. So I think there's so much scope for this. It's just to put that down in words. So as to Nandi, you asked an interesting question, also for the rest of the panel, but in my own view, I do not think that the law of armed conflict is the problem. I do not think we need new Geneva Conventions. I served as an expert advisor to the African Union's working group on the Continental Cyber Position that was adopted by the Peace and Security Council of the AU just 2 weeks ago. And the existing legal framework is there. It is adaptable to cyber, it is adaptable to cities, urban warfare. The problem is enforcement. That is what we need. And operationalizing these principles, unfortunately. So as you said, you mentioned so eloquently for a young voice, I was so impressed. You know, I don't know if I'm even that bold till this day. What is the meaning of these court rulings if we don't see the consequences? But I think one of the positive consequences were that we see an increase in peace talks. We see an increase in pressure on the United States of America, at least from other Western states, in terms of especially Rafah and continuous support. So at least we have that suddenly there's a microscope on what the IDF is doing thanks to this referral. The bill is another issue. I do agree with you that will be interesting to see what the budget says, but we don't have a ceasefire, but we have more attention, and I think it will be very difficult for certain allies to continue supporting should Israel not refrain in the way that they are currently combating. General, I look forward to your lived experiences. I'm sure Nandi is very excited and the audience to hear from you.
Thank you very much. My challenge, Advocate Nanipa, is my short military life has affected my hearing abilities. So please, if you don't mind, just be straight in terms of your questions, and also so that I can at least understand what exactly are you asking.
Thank you, General, and thanks to the responses from the great professors. General, the question is as follows. The center of the theater on October 7 was a kibbutz, which is a military veteran terrain in Israel. Now, the question I'm asking with regards to what you were raising, insofar as the social cohesion part that seems to be missing in this equation, insofar as the military doctrine. I'm then questioning whether this particular incident, it having happened at a kibbutz being a place where your social cohesion takes place, what does it then say in terms of forward-moving military doctrine? And I want you to link your response with the fact that you have raised an interesting observation that the IDF, with its astuteness insofar as the drone, robotic, cyber, but they were not able to have your sweeping insofar as this instance. What does that tell us in terms of geopolitical post? And I want, as you are responding, respond to us as Africans, because there are messages to us as Africans in the whole theater. Thank you.
Thanks, Advocate. Well, the challenge for whoever is wearing a military uniform is your socialization. I'm coming from a background where we are, as young boys growing up, were involved in stick fighting. And one thing which happens there in terms of the rules of the game, if somehow or other you lose your stick, the other fellow is not expected to continue hitting you. He's going to wait you until you are in a ready position to engage. Then you take that with you, you end up in the military. Through training, of course, you get to understand what different military weapon platforms can do. And of course, it's nice and very great to know what you can do to your opponent. But then there's also a restraint which is applied in terms of you are dealing with the opponents. They are not necessarily your personal enemies. This is a question of state versus another state. And therefore, yours is just to disarm them. At least put them at a disadvantage where they cannot engage. But don't go on and inflict unnecessary damage. Basically, that's that. Whatever background, social or cultural you're coming from, and even if you use different religious belief systems, you will realize that there's a certain stage in terms of humanity or wound, as it's been indicated, that you cannot continue beating a person who cannot respond. So that's a challenge for all of us. In the light of what's happening, whether it's in Russia, Ukraine, whether it's in Israel, Gaza, whether it's in Mozambique, there are limitations in terms of what you can do to another human being, especially when that person is not armed. Of course, then it goes to the issue of how far we civilized. That's that, because if you look at what's happening in DRC, where the armed groupings, what they do to women and children, a situation where people would go on, not only kill the person, but although they've got the weapon, but use a machete to cut the head off or to open the stomach of a pregnant lady who is alive. What informs that? What are you trying to achieve? And when you then coming from this part of the world and you see that happening on the ground right in the continent of Africa, then you begin to ask yourself a question. What causes this? Probably Professor Tube might want to indicate whether from a psychological point of view, what Leopold and company did in that part of the world, whether that kind of violence and management of the people and the killing of the people during that era is also affecting us as Africans having experienced that kind of barbarism from Leopold and company. So these are the challenges we're faced with. It's the same when you go to Mozambique. What kind of a person, regardless of what this person stands for, would do what they are doing in terms of beheading their own nationals? So those are the problems we are faced with. And the question is, how are we going to deal with that? From a military point of view, the only thing we can do is to try to make sure that you disarm the other person. Of course, there are many ways of doing that, using what you have at your disposal. Doctrine is informed by your strategy, but your strategy is informed by your policy. The unfortunate thing is how the politicians begin to define the other people. But at the end of the day, as a military, you've got to accept that, but take your own responsibility and accountability with what you have at your disposal. Because the politician, in terms of use of force, they are not necessarily at least the best. They can say what they want to say, but you need to understand what is it that the politicians are trying to achieve as a political end state, and then use the military means to achieve that. And lastly, Program Director, probably the politician from their side, they should learn that the military outcome is not the ultimate end goal. The end goal is a political end state, and that would come through the negotiation. The military can create a conducive environment for people to talk. That's all what they can do. Thanks, Advocate. I hope I've done justice.
You raised the question is now? the question, is human life more important than resources? And I believe as Africans, we know the concept of Ubuntu that Prof. Dube was talking about. And majority of us, we also believe in God being the provider. And if we're looking at the concept of Ubuntu, we realize that we need to be protecting other people next to us, would be protecting ourselves. So in as much as we need resources to be able to do whatever we may need to do, we also need to be able to put others first and believe that God will provide the rest. Thank you.
Thank you so much for that question, those questions, Advocate, and thank you for the responses from our panel of speakers. Colleagues, allow me to also consider our online community. There is, I think, a question or a contribution from Ms. Fana. I'll read. Initially, when I looked at the events in Russia and Gaza, my thought was that bombs are a bad idea in urban warfare and that snipers would be ideal to target the enemy. Since bombs cause major destruction on urban areas and casualties within a short period, then I looked at the situation in Sudan. That's when I saw that even a simple gun or machete could also be a bad idea. Snipers have an advantage. They do not destroy buildings, but civilians remain targeted. The recent situation of Hind, spelled H-I-N-D, then in brackets, child and medical personnel targeted in Gaza, serves as a good example. In my opinion, the problem is not the weapon, but those who control it, those who must uphold the rules of international humanitarian law. So just briefly, this comment or question was posed to Prof. Dube, the General, and, it was Prof. to the General, Mr. Mgwebi, and Prof. Bradley. Briefly, please just respond to that.
Thank you. I think it's quite correct that at the end of the day, it's the man behind the gun, not the gun, which causes the problem. So I agree with that, without at least elaborating on that. It's the man behind the gun. The gun itself is not a problem. It's just the application of that, and it's applied by the man. Thanks.
I think that is a very good question, and I recognize the name as one of my LLM students. So, Fana, I'm very happy that you're supporting this wonderful initiative hosted by Unisa. In my view, if weapons pass the Article 36 weapons review, meaning that they are compliant with international humanitarian law and they can be used in a discriminate manner, and they comply with conventions in terms of those type of weapons that's indiscriminate, like gases or so forth, that you cannot control the specificity, then in those cases, indeed, it is not the weapon. If you use illegal weapons that is compliant, then it is indeed the soldier or the fighter that is employing such weapons. And I think that is why it's so important that we look at these basic principles, because they speak to that person that is in fact targeting what the rules are.
There was no question.
There was none to you, Prof. Thank you for those responses. I hope Ms. Fana is answered. I will allow one more question. Yes, ma'am. Please pass the mic.
How to use it. Thank you very much to the speakers. We're really indebted to you for your insights. And I specifically had a question for Professor Bradley. You spoke about the principle of distinction and how objects can either be classified as civilian or military. I wanted to understand that, can an object exist as both of them simultaneously? And in those instances, what then maybe is the appropriate approach? That's what I wanted to understand. Thank you.
Thank you so much for that excellent question. So what we call these type of objects, but it's more a term of art because under IHL, or the law of war, you have either civilian or military. But the descriptor that we use is dual-use objects, meaning they both have a civilian purpose as well as a military purpose. For example, radio stations. It can be so that civilians use the radio station to broadcast during the day, and then at night, frequencies or messages are being employed by soldiers, the army, or rebel groups, and so forth. So in terms of targeting, what that essentially means is that when it is a dual-use object, it becomes military, yes, but there is a greater care that is expected. What I didn't discuss is the precautionary principle, and this is a principle that speaks to what you do before the attack, the intelligence assessment that has to be made. So for example, if you have a radio station that is dual use, and you know that the military is using it after hours when civilians are no longer there, then of course it would be ideal to intercept or target at night, when your collateral damage will be limited or none whatsoever. So this is when we hope that the operators consider those realities. Unfortunately, only military or civilian, so it might be that those responsible for targetable would say, well, it's a military objective, so now I can attack. But fortunately, also have the proportionality principle, which limits the collateral damage. But it doesn't mean that, oh, the hospital is now dual use, so all systems go. You have to consider the collateral damage as well, and to minimize. Another example could be if you look at electrical infrastructure. It might be that one power plant is essential to a military base, but it doesn't only power that military base, it also powers the village, and it's the only power plant that is available for that purpose. Then you should consider, well, can I not rather launch a cyber attack or something that will minimize the effect for civilians, since it's dual use? But excellent question, ma'am.
Thank you very much, Prof. For the interest of time, may your questions be very brief so that the answer is also the same. I'll allow the two gentlemen to ask questions from you to the other in that order, and then we'll respond to that.
Ladies and gentlemen, colleagues, good day to you all. My name is Howard Matladi, and I have only two questions, one directed at Professor Bradley and the other Professor Dube. I'll begin with Professor Bradley, and just now you were elaborating on the principle of proportionality and actually calculating. Earlier on you were talking about, you introduced a new legal framework, IHL. It was the first time I hear of it. And you talked briefly about the law of armed conflict. And my question is essentially this. Okay. Is it immediately understand that perhaps the Genocide Convention is more befitting to examine this with regards to Professor Dube, I've got an answer to your question whether or not the South African team might have missed a chance to address our own legal principles, and I agree that actually they should have done that. They should have talked about Ubuntu and other principles that were befitting, perhaps. The question that I have is that how can they introduce that at the international stage? Because okay, are there any mechanisms through which they can introduce that, or do we expect that to through the proceedings of the court? And it's actually not. Sometimes we might have our principles in these stages at an international level, because even when you consider international commercial law, particularly in arbitrations, when they determine jurisdiction, they must first agree on the seat of the arbitration and also agree on which law they're going to use. And I propose that perhaps with those principles or within those customs. That can be something which we can use to introduce even our own African of these legal proceedings. Thank you very much.
Good day, everyone. My name is Sinya McDuff, and I have two questions. I don't know if rather they're going to answer the first two questions posed, or should I also proceed with my questions?
Please proceed with your question.
My first question is directed to Ms. Zororo. It's based on the remark she made that will we ever come to an end of world wars, or will we ever have world peace? My question is, what measures are we taking as a nation to ensure world peace, and will we ever come to a point there isn't any war at all? That's the first question. And my second question is posed on Advocate Dube. My question is, looking at the position at which South Africa is economically, was it wise for them to embark on the case? And what are the reasons? The next question is, what are the advantages and disadvantages of them embarking on the case? Thank you.
Colleagues, may I also chip in? Please try and make sure that you ask one question in the interest of time. Thank you. The next question, please.
My name is Sipo Mantula from the TM School. I think mine, it is not a question but a comment to Prof. Dube on the Ubuntu principle, that if you can recall in the court application, the agent, Ambassador Vusi Wagama, Vusi, I don't know whether is it Umavimbele or yeah, raised the issue of Ubuntu as our foreign policy. That was another angle that we used there. But I think beyond that is what you are raising to say, develop your own customary law. And I think it has been done at some point. Maybe we have not been looking at West Africa and East Africa, how they have challenged the international norms. The other implication that was raised diplomatically by one of the young person there, I think you should go beyond diplomatic implications, because you are sitting with a wealth of knowledge there. There's a military implication also. There is intelligence implication of this current war. So you might look at the law, diplomacy, but there is an issue of national security. There's an issue of the military law as well as the diplomatic implication. And I think finally, what is important also is to address by my colleague here, the role of the United Nations Security Council. We saw it post this judgment, that we saw Algeria pushing for this immediate humanitarian ceasefire. So again, it is the role of Africans in the UN Security Council, whether as non-permanent members or as we are fighting for a permanent seat. So it will be important, once we get a permanent seat at the UN Security Council, we'll be able to become implementers and a pressure block in the ICJ judgments. But when you talk of ICC process with Middle East, it is toothless, because ICC doesn't have the power to arrest. It will rely on Interpol. But through ICJ and UN Security Council, there is an implication there. There is a pressure that we can use there. So I think those are my short comments. Thank you.
I'll allow our panel of speakers to respond to the questions.
Okay, since the question came to me first, I think it's very important to understand that the Geneva Conventions and the Genocide Convention is not mutually exclusive or the same, if I can explain it like that. Once you have an armed conflict, be it non-international, meaning between a rebel group within boundaries against the state or two states against each other, then the law of armed conflict is triggered, and the way that actors then engage their military operations and attacks are governed by IHL. However, it is possible that genocidal acts might also occur or be committed. So genocide can take place in peacetime or if you think about it, it is unfortunate reality. Think about Yugoslavia, where the ICTY decided both on war crimes concurrently with the commission of genocidal acts. The same was true for Rwanda. The same was true for World War II. So definitely Israel and the IDF is bound, as well as Hamas, are bound by the law of non-international armed conflict, which is essentially IHL, or the law of war in NIAC, which is non-international, plus Israel is bound by the Genocide Convention because it is a signatory, not to commit acts of genocide, which means there is that genocidal intent. But often the two goes together. The genocide is committed in armed conflict by states because states have access to the military, to the machinery that can actually allow for the commission of horrendous acts such as genocide. So Israel as a state, the IDF, are bound by both the law of war concurrently and the Genocide Convention. So I hope that answers your question.
Thank you. The question on how do we then introduce Ubuntu, and it might tie into what Moafrika Mandula talked about. There are three methods we could do this. We could introduce Ubuntu as a substantive principle and argue it as such within the court, or you could use it as a procedural principle, or it could be used on the third leg as an interpretive principle. In other words, in order to interpret the actions of a particular party to the court to see if they fall within the ambit of Ubuntu. When we use elements or norms and principles from IHL, such as humanness, we could have gone a step further and said, over and above humanness as understood from a Eurocentric mold, there is an African perspective of looking at this, which is Ubuntu. So we could have introduced it like that by arguing it substantively, or by arguing it procedurally, or using it as an interpretive aid to assist the court to arrive at a particular decision. The economic standing of SA and what are the advantages and disadvantages of SA engaging in this. Look, whether South Africa was right or wrong to take the matter to the ICJ is a debate for another day. What should be at the forefront of this is that we are a sovereign nation, equal to any other, even the military bully of this world, the US. When it comes to international law, we're equal sovereigns. Biden cannot tell us what to do. We do what is in the national interest of this country. We are a country that believes in humanity, believes in Ubuntu, believes in equality, believes in human freedom. We have obligations at the international level. We sign, we ratify. You know, there are so many norms or so many treaties that deal with war crimes, crimes against humanity, and genocide, that some of the norms that we stand up to defend are now part of customary international law. We are automatically bound as members of the civilized group of nations across the world. We therefore have obligations as a country to stand up and defend when we see a fellow state, who is our sovereign equal, by the way, where we see that sovereign equal violating its own citizens or violating individuals that are found on its territory. We will always be faced with that question because some people, and I'm not saying that's what you are saying, but I'm saying there have been sentiments on social media and everywhere where people are saying, but people are hungry, but people don't have electricity. Those are sentiments coming from a standpoint of myopia, failing to see beyond that door. You know, society is full of people who are failing to see beyond the stage. That it's not about the guy sleeping under a bridge. You know, it's not about that guy. It's about the world we want to live in. Today it's Israel. Tomorrow it's South Africa. If South Africa doesn't stand up and defend the victims of the Israeli excesses, tomorrow we'll be seeing it happening here and we'll be expected to keep quiet. Nobody kept quiet when Hitler was bastardizing the Jews. Why should we be quiet today? So what are the economic implications for this? Of course, this is international relations. America is now going through a process of trying to review whether they should continue, you know, their economic relations with us. airlines cut their routes to OR Tambo immediately after the ICJ decision. Does it matter to our economy? How often was LI flying to South Africa? Not even every day. How many people was it carrying to South Africa? We don't care. They can fly anywhere else. We're going to continue to negotiate routes with other airlines to ensure that the economy is vibrant. There will always be economic implications for complying with the law and for not complying with the law. But rather let history judge you and find you on the right side of humanity, having taken up the stand, to defend humanity, to defend the sanctity of human life, because umuntu ngabantu, even the person in Palestine is still a person, even though they are referred to as a human animal. Thank you very much.
Yeah, I think Prof. Dube has already answered the question that was posed for me. But I cannot answer whether or not this is going to lead to a world war. But I think, as Prof. Dube has just mentioned, South Africa is on the right side of humanity, and they will do anything that they possibly can to try and protect human life. I mean, he just mentioned how South Africa is trying to get a permanent seat in the UN Security Council. I think that's a very big move. And with that, we will be able to have decisions, to be part of the decision making, which is very critical in this regard. Thank you.
Thank you very much for those questions and the responses. I will take the last two questions which I see from our online community. One is directed to General Mgwebi and Prof. Bradley, and it reads, who is wrong, the one using humans as shields or the one who's bombing the human shields? And if one was a military commander, what would be the ideal way to deal with the situation? And the last question is directed to Prof. Dube, and it reads, is it offered up as a principle to be lumped together with others, or is it a proposed meta foundation for all of international law? This is on the notion of Ubuntu. Thank you.
Thank you. That's a very interesting question. Who is it right or wrong? In terms of military tactics, and of course based on the doctrine, we should, all of us, staying away from where the civilians are. That's the basic understanding. But the challenge for those who are non-state actors and who are not endowed with quite sophisticated weaponry, they tend to use the civilian population as a forest, which does not make it right. But that's what they tend to do, fully knowing that they are trying to restrict the application of the weapons by the big guys. But at the end of the day, their actions are not right. But that's what they do. Again, the issue of proportionality, for those who've got all the weaponry in their arsenal, they've got a responsibility. They've got a responsibility that if the non-state guy or the terrorist or the guerrilla, whatever term you want to use, is going to use what's available at his disposal. But you need to at least be above what that other person is doing to show your military professionalism, your own credibility and legitimacy in terms of prosecuting a war. Therefore, in that light, if the other person does use civilians as a shield, you've got to analyze the target. And also, you need good intelligence. Your selection of the weaponry you have at your disposal determine at the end of the day whether you did take into account the presence of civilians. And therefore, the level of collateral damage then becomes at least the issue. Just the issue of the last parting shot.
In Liberia, the Ghanaian patrol commander, who was a lieutenant, had a challenge from a school where the sniper was taking his soldiers. Remember, a platoon commander is a young fellow at the age of 24, 22. The emotive part of it, when your soldiers are going down in that crisis, and you then determine where the fire is coming from. At his disposal, he had all the weapons available. He decided to use a mortar. Within the mortar section, there are different types of mortars. He went for the most, at least lethal one, the explosive, high explosive mortars. And he bombed that school to nothingness. Of course, at the end of the day, he was found guilty from the Ghanaian side for what he did. But the decision which was taken at the time, if you look at that commander at that age, it's a very challenging thing for him. It's a very challenging thing because now when your own are dying, that's what you carry as a commander. How many of them you're able to save their lives and take them back home to their own families? And somebody is using a school as a shield. But at the end of the day, you are not right when you go beyond what can be done. Thanks.
The General answered that so beautifully that I have very little to add. I think just for those who are not IHL lawyers in the room, in terms of international humanitarian law, you're equally bound by the rules. If the other side breached the law, it doesn't give you a license to kill or to not obey. So there's no tit for tat. They use a human shield, which is illegal under IHL. You cannot use civilians as human shields. Now I can bomb the entire apartment block city adjacent. That is not how it works. Both sides, all parties to the conflict, are bound by the rules of IHL. In the case mentioned, both sides are in violation of international humanitarian law.
Thank you. The question from the online group is about the usage of Ubuntu. Should it be used as a meta foundation for all of international law, or should it be lumped together with others? We come from a situation where we are saying international law as it stands is Eurocentric. It only looks at Euronormativity. What is normal to the north is exported and universalized, and it is said to be universal, applicable to everyone. We're saying take from the south as well, put it there and say it's universal to everyone. We're not saying substitute the principles that exist with ours. We're saying let all principles coming from humanity come to the table and be used to develop international law. So the quick answer to that is that we're advocating for Ubuntu to be included not as a substitute, but as an included norm from what was once regarded as an uncivilized nation, the barbaric, the savage. It is now civilized. Even if you don't want to admit, take these norms. That's what we're saying. Thank you.
Please, let's clap once again for... I would like to thank our panel of speakers for the responses to the questions. I'd like to also thank the gallery for the questions and comments that have been posed concerning the deliberations today. Colleagues, in the interest of time, allow me to call upon Dr. Mhlongo, who is going to present a token of appreciation to our panel of speakers. Doctor.
Thank you once again to our speakers for honoring us with your presence, with your knowledge, and we really, really appreciate Ms. Zororo. You always show up. Just last week, colleagues, she was here with us. We were deliberating on the post-SONA, and she came through, and here she is once again today. So we really, really appreciate and do send our regards to the team. General Ngweb, he's coming all the way from Eastern Cape. And he is retired, but he decided that I was going to grace us with his presence, making time when he could have spent it with his family. Please accept our highest kind regards. We really appreciate your presence. And Prof. Bradley, she's part of the family. When we were teaching international law with Prof. Dube, she used to be our external marker. And for Silsa, I must say that every time we request her to review a paper, she's always willing to do that. And she actually do the review and give it to you within the requested time. You never have to follow up. So we really, really appreciate your efforts in building the College of Law at Unisa, Prof. And Professor Dube, when I requested him to be part of the panel, because he is the director and his office is very busy, he put some time aside today to actually be with us. I'm sure just by him sitting here, he has thousands and thousands of emails that he has to go and deal with, and we really appreciate you making the time to be with us. And colleagues, this seminar wouldn't be possible without the support of the deanery. They might not be here, but they are behind the seminar, and we really appreciate their support. Prof. Olawose John Kole, who is our acting executive dean, and Professor Budeli Nomakonde, who is our acting deputy executive dean. We really, really appreciate their efforts and their support, and we will hopefully see you, all of you, in the next event. Please look out for that either in our social pages, or some of you are in contact with us, so we will be planning something. Please do pull through and support. And to the organizing committee, I also would like to thank you as well. You've made this event a success. To the media team, we were actually with them last year during the conference. They always support us. We really, really appreciate you. And please do support other events with us or other stakeholders within the Unisa community. And with that, colleagues, please, I would like to request Professor Dube to assist with the gifts. Ms. Zororo, you can please come through. General Mgwebu, please come through. Thank you.
With your permission, Doc, behind there in the darkness, there is militarily you don't move without fire support. You don't move at any given stage. We've got a general who is sitting there, if my eyes are still serve me correct. Yes, that's General Yam.
Wow. Oh.
Thanks, Chonyane. General Yam is a retired Lieutenant General who was in his, it's still your time, I must say, during his time. He was once at least in charge of our military academy down in the Saldanha, linking up with Stellenbosch University. And he became Chief of the Army, and then he retired as a Chief of Staff of the SANDF. So you've got at least a resource there. So this is why I said you don't move militarily. Thank you very much.
Thank you so much. And We do welcome you and appreciate your presence, General Yam. It really means a lot. I have been engaging with him as well, and hopefully in future he will also be joining us and form part of the panel in one of the events that we are going to plan. But we do really, really appreciate you showing up. Thank you so much. Prof. Bradley. And colleagues, thank you so much to each and every one of you for your presence, for supporting Unisa, College of Law, the Unisa community, and for always showing up when we request and send out the invitations. Our online community, thank you so much. We really appreciate you making the time, even though you couldn't be here in person to join us, but we really do appreciate you coming, and please do enjoy the rest of your day. Thank you so much. Bye.